the attorney is alleging, hey, you illegally detained him for 17 minutes. So anything you got during that period has to be suppressed, can't be used. And then after your illegal detainment, you took him to the police station, your buddy, hey, you want food? You want soda? He takes, soda or whatever it was, and then you grab his DNA off the soda can. Hey, it's Jordan. I am in Flint, Michigan, East Palestine, Ohio, Tumwa, Iowa. Please support the only independent outlet on the ground covering what the corporate media covers up. Hey, it's Jordan with Status Coup. Big news in the case of Luigi Mangione, the alleged shooter of United Healthcare CEO Brian Thompson, where Luigi's attorney in Pennsylvania, Thomas Dickey, has filed another explosive, I believe very explosive, motion requesting that a judge dismiss all of the Pennsylvania charges against Mangione and alleging that Altoona police, that's where he was arrested, Altoona, Pennsylvania, illegally obtained Mangione's DNA, also alleging and asking that the judge toss any of the evidence that the Altoona police obtained through the search of Mangione's backpack that was done without a search warrant at the time. And also, the attorney is requesting that if this goes to trial, that prosecutors are not allowed to use the term manifesto for various reasons. There is major new allegations in this. It's a long document, 36 pages, so I'm not going to read all of it, but I will read the parts that I believe are most important here. Again, this was filed a few days ago, just became public, I believe, last night. At the time of the stop, meaning Luigi's stop by police at the McDonald's, arrest, seizure, and investigatory detention, Altoona police officers told the defendant that he looked suspicious, quote, looked suspicious, and gave directions and commands to the defendant to perform certain tasks, included but not limited to providing his identification, standing up, sitting down, placing hands on head, as well as a Terry frisk, pat down. They also questioned him about being in New York. At no time did the Altoona police officers indicate to the defendant that he was free to leave. This, again, is important. Again, I covered this in the original motion that Dickey filed, I believe, a week or so ago. They had detained him for approximately 17 minutes without reading his Miranda rights. And if you are detaining a potential suspect, you have to read their Miranda rights if they're being in a custodial detention. They did not read him his Miranda rights for over 17 minutes. So this motion continues to point out that he was being detained, yet had not been read his Miranda rights. The totality of the circumstances, including but not limited to the positioning, demeanor, mannerisms, commands, directives, instructions, and other actions of Altoona police showed that at the time of the request for identification, compliance with this request was required, meaning you were being detained. During the stop, arrest, seizure, and or the investigatory detention of the defendant, Altoona police officer requested that he produce identification. Under the totality of circumstances, the production of identification was not an act of free will. The Altoona police took possession and control of identification materials presented by defendant and continued retention of this material. The positioning of law enforcement officers, personnel, and the retention of a person's identification materials for a background check, evidence of criminal activity, and or investigation measures signal to a reasonable person that they're implicitly commanding that person to remain on scene while doing so. So I'm going to skip around now because this part is particularly important. A member of the Altoona Police Department questioned the defendant about whether or not a backpack, plastic bag, and other items belonged to the defendant at the time. At that time, the Altoona police officer seized the items and packages and placed them in an area behind law enforcement personnel so that several police officers were positioned between the defendant and the seized items. At all times thereafter, Altoona police officers remained stationed between the defendant and the items of property believed to belong to the defendant. These items of property remained in the control of Altoona police throughout. Defendant believes this action further supports his belief that he was not free to go. So again, Thomas Dickey, his attorney, is pointing out that he was being detained. He was basically under arrest without being read his Miranda rights. I want to get to this part here. Throughout the interaction with the defendant, Altoona police officers and other law enforcement personnel continued to detain, interrogate, and question the defendant without any reading of his Miranda rights as required by both the Constitution of the United States as well as the Pennsylvania Constitution. These questions were designed to potentially incriminate the defendant. The nature, duration, and conditions of the investigated detention by Altoona police officers and other law enforcement personnel at this time became so coercive as to be the functioning equivalent of an arrest. It was clear that a custodial detention interrogation was occurring at this time. The custodial interrogation was performed without probable cause to arrest, stop, seize, or otherwise detain the defendant. This custodial interrogation required the reading of Miranda rights warning as required by both the Fifth Amendment of the Constitution of the United States as well as Article 1, Section 9 of the Pennsylvania Constitution. So what he's doing here, like he did in his previous filing, is meticulously laying out that he was basically illegally detained for as long as 17 minutes. So everything that happened in that time span before the reading of Miranda rights, nothing can be used. It all has to be suppressed, including the seizure of his backpack and what they obtained from the backpack. Let me show you more here because this part is also pretty important, what I'm about to read to you. After the defendant shook his head no, indicating he did not want to talk to police, the Altoona Police Department continued to question and interrogate him anyway. He was then subjected to another Terry frisk, that's a pat down. He was then placed in handcuffs and was informed that he was being detained. For reasons stated, it is the defendant's position that he had already been illegally seized, detained, arrested, and in custody, contrary to the protection provided by both the Fourth Amendment and the 14th Amendment of the Constitution and the Pennsylvania Constitution. A photograph was taken of him by an agent of the Pennsylvania Attorney General's office. Members of the Altoona Police Department continued to interrogate the defendant despite indications by the defendant that he did not wish to speak to law enforcement. Approximately 7 minutes later, defendant was physically removed from the McDonald's due to, according to police reports, being placed under arrest, taken into custody for the crime of, quote, providing false identification to law enforcement and transported to the Altoona Police Department. Said arrest was illegal and unlawful at this time, insofar as the defendant did not commit the crime of false identification to law enforcement. Any arrest of the defendant at that time was illegal, and or any charges alleged against him was based on evidence received as a fruit of an illegal stop, seizure, detention, and or arrest. Again, referring to he was detained without reading of his Miranda rights. All actions of law enforcement personnel on that date being both singularly and collectively in violation of the defendant's rights via Fourth Amendment, 14th Amendment, and the Pennsylvania Constitution. At the same time, members of Altoona Police commenced a thorough search of the defendant's backpacks and other items while at McDonald's. Defendant avers that the search and seizure was illegal and unlawful insofar as the same was undertaken without a warrant. During the search of the backpack, the Altoona Police uncovered a clip wrapped up in underwear, and other items contained within the backpack was a separate package secured by duct tape. Said package was opened via removal of the duct tape with a knife by members of Altoona Police without a valid search warrant. That's important because we will get to the search warrant aspect later on in this motion. Moving on, insofar as the arrest, seizure, and detention of the defendant, as well as the search and seizure of the backpack and other packages, was contrary to the protections afforded to the defendant via Fourth Amendment and 14th Amendment, as well as the Pennsylvania Constitution, any and all items obtained from the defendant on December 9th and subsequent dates should be suppressed, and the Commonwealth should be precluded from use of the same. This would include any lists all of what was obtained, the original identification card seized from the defendant, any and all items listed in Exhibit B, and those would include, reading from Exhibit B, the 9mm gun, his identification, the receiver, 3D printed suppressor, red notebook with his notes that police labeled the manifesto. Wherefore, as a result of the violations of the state and federal constitutional protections which are afforded to the defendant respectfully requests and prays that the Honorable Court enter an order finding that the initial stop, seizure, and detention was illegal and unlawful, finding that the continued stop, seizure, and detention was illegal and unlawful, and finding that any arrest of the defendant was made without probable cause or other legal justification, suppressing and excluding any physical evidence seized and or provided by the defendant insofar as the same was obtained illegally, suppressing and excluding any and all statements uttered, made, and or obtained from the defendant, suppressing and excluding all evidence seized as a result of the warrantless search of the defendant, suppressing and excluding any and all evidence that has been seized as the fruit of the poisonous tree. Now I want to get to the DNA part here, which is pretty big, I would say. While illegally seized, arrested, and detained, the defendant was provided food and soda while at the Altoona Police Department station. The purposes for the same was to obtain the DNA from the defendant for further investigative purposes. Insofar as the defendant's detention was illegal for reasons set forth, any and all DNA samples, profiles, were poisonous fruits obtained in violation of the protections afforded by the defendant by the constitutions of the U.S. So basically, the attorney is alleging, hey, you illegally detained him for 17 minutes, so anything you got during that period has to be suppressed, can't be used. And then after your illegal detainment, you took him to the police station, your buddy, hey, you want food? You want soda? He takes, soda or whatever it was, and then you grab his DNA off the soda can. So Mangione's attorney is basically stating, since everything before that was illegal, that can't be used too, what they call fruit of the poisonous tree in legal terms. Let me read this point here. It is alleged that during the arraignment before Magistrate Ben Jones, the defendant made certain statements. Defendant had previously invoked his Fifth Amendment right to remain silent as protected by the Fifth Amendment of the Constitution of the U.S., as well as Article 1 of the Pennsylvania Constitution. Said statements were obtained in violation of the aforesaid protections. The purported meaning of the statements is based on speculation by the Altoona Police Department. Bottom line, he invoked his Fifth Amendment, so anything after that can't be used, regardless of what the Altoona police claim, he said. And then reference to the, quote, manifesto, the Altoona Police Department illegally seized a notebook which allegedly contained numerous personnel writings covering a plethora of personal experiences of the defendant. A member of the Altoona Police Department improperly and without justification labeled these writings and or notebook as, quote, manifesto. The use of this characterization of the defendant's alleged personal experience and writings is incorrect, improper, and without justification, and has no probative value. Defendant believes that this characterization was done so solely for the purpose to prejudice the defendant and put him in a negative light before the public, all in an effort to prejudice any potential jury pool. And the attorney basically requests to dismiss all charges based on the illegal detention, as well as what he is saying is the illegal capture of Mangione's DNA, and not be able to use the term manifesto if this case went forward, as well as not be able to use any of the evidence seized from the backpack because there was no search warrant for the backpack at that time. I want to play you a video which I think kind of encapsulates all of this. This is from a Pennsylvania attorney who has followed this case. He does it a little quicker than I did, but I wanted to read to you, the relevant passages. But this is Pennsylvania attorney David Betras. I hope I'm pronouncing that right, or David Beatrice. Let me play for you his recap of this, in addition to a separate motion, which I couldn't find, for which Mangione's attorney says, yeah, we're not going to do any further court hearings through Zoom. You have to bring him back in person.
During the COVID pandemic, a lot of courts tried to do a lot of hearings via remote Zoom. Now Tom Dickey, being the badass that he is, demanded the Common Pleas Court that his client will have to attend the hearings in person. Now let me read to you right from the badass certificate he filed. And now, the 7th day of March, 2025, pursuant to this court's order of February 14th, 2025, the defendant and his counsel hereby certify the defendant does not consent to appearing for any future court dates by use of two-way simultaneous audio visual communication pursuant to some Pennsylvania statute. Defendant further believes and avers that he has a statutory and constitutional right to be physically present at all pretrial hearings as protected by the Sixth Amendment of the United States Constitution, as well as Article 1, Section 9 of the Constitution of the Commonwealth. Now let's go to the supplemental amended omnibus pretrial motion for release. Part 1, a petition for writ of habeas corpus. What is the badass saying? He's saying, hey, you didn't make a prima facie case. You're holding my client unlawfully. Then he goes into a motion to suppress. Suppress everything. He goes into that. Then he goes into another motion to suppress. The warrantless search of the backpack, bag, envelope, containers, computer chips, and other property purportedly belonging to and or to be in the possession of the defendant. Then what's he file? He files a motion to suppress the DNA. Yeah, here's what they did. Oh, hello, LM. Would you like a Coke? Here, have a Coke. Yeah, he drinks the Coke, then they take the DNA off of it. You know what the badass said? He said, you arrested him unlawfully? That's called fruit of the poisonous tree. Then he goes through a number of motions to quash everything, saying, look, you're holding my client unlawfully, you didn't make a prima facie case, and therefore all of the charges in Pennsylvania should be dismissed. And then right here, this is a motion to suppress the search warrant. There are 2 search warrants issued here in Pennsylvania. Yeah, bet you didn't know that. One is 12/10 of 2024, 12:17 p.m. Now, I'll tell you all about prima facie another time. And he says this is not a Franks hearing, and I'll explain to you what a Franks hearing is. But he's saying you didn't have probable cause for the motion for the search warrant on 12/10. And there was another search warrant on 12/9. He's going, you didn't have probable cause for that. Then he files the motion to suppress any statements allegedly made at the arraignment. He's saying, look, my client invoked his Fifth Amendment right to remain silent. And anything that these police officers say he said, he invoked his right to remain silent. That should all be suppressed.
So that is a very good kind of summary of everything I told you about. Like I said, his case is coming up a week from today in New York. March 19th will be his next hearing for the federal case against him. So there's a lot going on. But if Mangione and his Pennsylvania attorney are successful in suppressing evidence that was allegedly found on his person, are successful in suppressing DNA evidence, that could definitely have ramifications for the other cases because his arrest was in Pennsylvania. And obviously, prosecutors in New York are going to want to use evidence that was allegedly obtained in Pennsylvania. So stay tuned. We will continue updating you as this case develops. Please continue supporting Status Coup. As far as I know, we're one of the only outlets continuing in depth to stay on this important case because the ramifications are beyond Luigi Mangione. This is about the predatory, murderous, for-profit health insurance industry. Please support us for as low as $5 a month. StatusCoup.com/join.